Welcome to today's program titled ERISA Litigation 2022 Mid-Year Update. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Rebecca Bryant. Rebecca, please go ahead.
Thank you, Kate. Good afternoon, everyone. My name is Rebecca Bryant. I'm an associate attorney at Seyfarth, and I want to thank you all for joining us today. And I must start by saying that I'm thrilled that ERISA Litigation brings hundreds of people together on a beautiful Tuesday afternoon like today, at least if you're in the Chicagoland area as well. It is my distinguished privilege to be co-presenting today with preeminent ERISA litigator Ian Morrison, who is a partner here at Seyfarth in Chicago as well. Because we've prepared such a substantive update, we are going to move right into discussing the topics for which we will be exploring today. First, we will discuss fiduciary claim actions, both in the 401k class action space and then in the health and welfare space. We will also be discussing key pending appeals and decisions related to arbitration clauses. And then finally, we'll take a quick look at legislation efforts that are on our radar and we think should be on yours as well. So without further ado, I'll turn it over to Mr. Morrison.
Thanks, Rebecca. And if we could go to the next slide. 401k fee litigation, you think for a minute that you will have a little breather and you can kind of settle down and figure out what's going on, and that doesn't happen, unfortunately. It has been an action-packed year thus far. Some of you may have attended our program on the Hughes decision that came out earlier in the year, and now we've got already several appellate court decisions building on Hughes and a few more in the pipeline. So we wanted to update everybody on what's going on in these cases. And at this point, I think it's fair to assume most people are familiar with the basic claims and issues in the cases. They continue to proliferate at a very high rate, and how the courts will handle them is something we really need to pay critical attention to. So just by way of background, the Hughes decision came out of the Seventh Circuit. Both the district court and the Seventh Circuit had dismissed the case under Rule 12b-6 based on failure to state a claim that on which relief could be granted. And one of the reasons that the courts found there was no claim was, in effect, because the plan had several complained of options and then several options that sort of fit within the definition of what the plaintiffs were saying were indisputably prudent. And the court said, well, if the plan has the things you want, how can you really have a claim? Case goes up to the Supreme Court. The Supreme Court, after an argument that left everyone sort of scratching their heads in terms of what direction the court would go, issued what was pretty narrow decision. They unanimously, one judge recused because she'd been on the Seventh Circuit at the time of the decision under review, but the remaining justices unanimously reversed and sent the case back to the Seventh Circuit for further consideration under what's referred to as the Twombly-Iqbal standard for motions to dismiss. And basically what they said is the linchpin of this decision was this notion that because the plan offers prudent options, there can be no challenge to the imprudent options. They said that's not correct. under their earlier Tibble decision, which had held that fiduciaries have an obligation to continuously review investment offerings and plan fees. So they said that's not a good enough reason to dismiss a case. Go back and consider whether the complaint plausibly alleges a breach of fiduciary duty if you move that argument off to the side. One thing that's important about that holding is that it did at least settle one question the courts had split on, which was whether Twombly and Iqbal applied to ERISA cases. The Third Circuit, at least in the Sweda versus University of Pennsylvania case, had held that those decisions were limited to their particular factual context and legal context and didn't apply in ERISA cases. And clearly the Supreme Court disagreed with that when it sent the case back. But there's going to be more from the Seventh Circuit, it appears, rather than simply routing the case back to the district court for further review in light of the Supreme Court decision. There has been one round of briefing already, and now the parties are engaged in full merits rebriefing, and there will be argument. I believe the plaintiff's brief was filed on June 1st, and I think that Northwestern brief is due beginning of July. So we will have more from the Seventh Circuit very soon. If we go to the next slide, we did get a sneak peek of what might come from the Seventh Circuit last week in the case called Albert versus Oshkosh, which is pending at the Seventh Circuit and was argued on the 6-2 rather. This case was one of a large number of kind of cookie cutter 401k fee cases that was filed in Wisconsin. A number of them ended up in front of Judge Griesbach in Green Bay. And the Oshkosh decision and another one that we handled were argued kind of back-to-back days. And the judge issued a decision in Oshkosh dismissing the complaint based on the Seventh Circuit's decision in Hughes, which has now been reversed. And the next day, he then issued orders in most of his other cases that were similar, staying them pending the outcome of Hughes. He then refused to grant the plaintiff's motion to basically reopen his decision in light of the pending Hughes appeal, and the appeal to the Seventh Circuit ensued. And argument happened last week, and during the argument, Judge Easterbrook, who was on the panel, kind of pointedly and several times said something to the effect of, don't these cases all have to go to summary judgment? Isn't the import of the Supreme Court's decision that there are fact questions about the reasonableness of the fiduciary's conduct that mean you can't get out on the motion to dismiss? Defense counsel did I would say, a very good job kind of trying to refocus the court on the fact that Twombly and Iqbal don't really set that bar. I mean, Easterbrook's comments suggested that he was reading Hughes almost in isolation and ignoring Twombly and Iqbal, which set a pretty high bar for pleading a plausible claim. But we know at least one judge on the panel was I think, firmly in favor of sending the case back to the district court. So we'll see. I would imagine we'll get a decision on that case later this summer unless they decide to hold it up and kind of issue in tandem with the Hughes remand decision. If we go to the next slide. Also last week, it was a busy week. The Third Circuit issued a decision in the Boley case on another 401k fee question that's been litigated extensively, and that's standing. And they did it in the context of class certification, but their takeaways both for class certification and for standing. And defendants in these cases have been arguing, based on the Supreme Court's Stoll decision from 2020, that to have a standing to sue, you have to have invested in the funds that you're challenging. And so if you have a plaintiff who's suing and saying all 20 of the plan's funds are imprudent, but only invested in one, say the target date fund, defendants will commonly say, well, you don't have standing to sue about the other claims. And I think that's actually correct under the Stoll decision, because the Stoll says, if you you apply rule or Article 3 standing rules to ERISA. There's no ERISA exemption to Article 3. And if the outcome of your case wouldn't make a difference to you, then you don't have an injury in fact and you don't have standing. But the argument's met with a good bit of resistance from the courts. Most of the district courts that have been presented with the argument have said no and allowed the cases to proceed. There have been a couple that, limited the case to the specific funds that the plaintiff invested in. And the Third Circuit, in its decision, essentially rejected the argument for both standing Article 3 purposes and class certification and said, because the class here was challenging a number of investment options really for common reasons, they alleged overall defects in the fiduciary process that cut across all of the investment options, that was enough to allow a plaintiff who only invested in a few of them to sue. It's not clear, we noted the last bullet point here, not clear whether this decision will apply to every 401k fee case. I'm sure that plaintiffs' lawyers will point to it, but according to the Third Circuit at least, it is the ruling was built on the notion that the claims here were sort of uniform claims that cut across the whole plan. And I think it creates a tension because oftentimes you'll see a complaint that tries to attack all of the investment options in the plan, and that's really pushing the limits of sort of plausibility and challenging all of the investment options and saying they're all imprudent or they're all in the wrong share class. And the more, more skillful plaintiffs' lawyers will select ones where there's actually a plausible case to be made, or they think there's a plausible case to be made. And so if you go with the narrower attack, you may leave yourself open to the standing issue as to any other funds that the individual plaintiff didn't invest in. Go to the next slide. That we've tried to sort of briefly summarize a few other recent notable fee class action decisions. The Ninth Circuit issued two, the Davis case and the Kahn case, which is on the next slide. Both of them reversing district court grants of motion to dismiss in sort of garden variety 401k fee cases. And frankly, the Ninth Circuit decisions were a little light on kind of reasoning and direction. They basically took Hughes and said, well, see Hughes reversed. And so, we're left from those decisions with not much to understand what it takes to plead a claim, other than that, according to the Ninth Circuit, those two complaints stated a claim. So perhaps from the Seventh Circuit's decisions, we'll get a little bit more instruction and help in figuring out what's a viable claim and what's not a viable claim. And go to the next slide and briefly talk there about the Trader Joe's decision, which was issued a week and a half after the Salesforce decision. And there have also been a large number of district court decisions that have come out in the wake of Hughes. I would say that overwhelmingly courts are denying motions to dismiss now and allowing the cases to proceed, which creates a significant challenge for plan sponsors and plan fiduciaries, because these are expensive cases to defend. They require a lot of time from lawyers and management, and the courts seem to be fairly unsympathetic about those burdens that are being put on fiduciaries. But I think what their courts are also pointing to is they want to see the facts. They want to see the evidence about what prudent processes were used. So I think what we will need to do as these cases proceed forward is, if you're defending, to really focus on getting your ducks in a row from an evidentiary perspective and putting forward your best case to show that there was a prudent process and being prepared to do that at summary judgment, as soon as you can. Because I think while the courts have been ultimately fairly unreceptive to motions to dismiss, I think once you show them the facts in most of these cases, their views will be vastly different. And if we go to the next slide. 1.2 of interest in this litigation, the U.S. Chamber of Commerce has started to get involved in these cases, doing some advocacy work in the way of amicus briefs that they've been filing in the district courts, which, so far it's hard to tell whether that's having a significant effect, but it definitely is the right idea to try and sort of shape the law early on. I think the other thing that has been discussed a lot is whether there is some sort of a legislative solution to this wave of litigation, and something that certainly those of us who represent employers and fiduciaries are thinking about. And if we go to the next slide. So key takeaways. Unfortunately, it's been a bumpy ride so far this year in the 401k fee world if you're a defendant or a employer or plan sponsor or fiduciary. It's hard to get an exact tally, but we think there have been more than 240 of these cases that have been filed since 2005. 90 plus of them in 2020 alone. There have been a good number of them this year. And as I noted, pleading is one thing, and it may be the case that courts come down on the side of saying, a 100-page complaint reciting a lot of concerns about 401k options and fees is enough to get by the motion to dismiss, but whether the plaintiff can prove it is an entirely different thing. Settlements in these cases have been large in the past. I would say most of the cases that are settling now settle for much smaller numbers. And I think that's a function really of the fact that the evidence is ultimately relatively thin in these cases. And so, between thin evidence to persuade a plaintiff to take a reasonable settlement and the cost of defense, that has often produced, resolution in these cases. And the last point, I think, is kind of the key takeaway. The best defense is often a very good offense. And on the next slide, we've kind of outlined a few things that fiduciaries can consider if they're not already doing them, and many of them are, to kind of build that prudent process and protect yourself going forward. And really, these cases, because they turn on process, put the onus on the fiduciaries and their advisors to, do their homework, dot their I's and cross their T's, and we've just kind of captured here a few of the things that may be helpful for fiduciaries to consider. And I believe with that, I'm going to hand it over to Rebecca to update us on fiduciary issues on the health and welfare side of the house.
Yes. So one of the biggest cases that have come down recently in the health and welfare space has been the WIT v. United Behavioral Health case. If we go to the next slide, you'll see that in March of this year, the Ninth Circuit reversed the decisions of the U.S. District Court for the Northern District of California, which had ordered UBH to reprocess over 67,000 claims in part for behavioral and mental health treatment. And it had found that UBH had breached its fiduciary duty under ERISA for denying their claims as a result of these allegedly pervasively flawed medical necessity criteria that the court had concluded wasn't consistent with generally accepted standards of care, which is a term of art. And the Ninth Circuit agreed that the plaintiffs had standing and certifying was not an abuse of discretion, but instead that UBH had properly exercised discretion in creating its the guidelines, which the underlying health plan did not expressly require consistency with the GASC, only that they not be inconsistent. So this mandated reversal of the district court's finding of liability for UBH. But it is not over. Going on to the next slide, you'll see that there have been, there's a petition for panel rehearing en banc, which was filed last month. And so the class of participants and beneficiaries have asserted that the Ninth Circuit's March ruling, if not reversed, would have nationwide consequences for health plans regulated by ERISA. And they, along with 9 other healthcare advocacy organizations, have requested a rehearing en banc. And it's unclear really what the impact will be. Previously, when the WIT litigation at the district level came down, it was considered a landmark decision for mental health class action, and it spurred lots of other litigation and even regulatory action and some legislation. And so this will be a case to watch, as UBH's response to the petition for rehearing is due next week. And if we go on to the next slide and on over to the 8th Circuit, this Skelton v. Reliance case just came down last month. The 8th Circuit affirmed the district court's finding that Reliance, the insurer in this matter, failed to fulfill its duty to verify premiums. That premiums only came from properly enrolled participants. By way of background, Reliance had basically advised this participant, Ms. Skelton, that she would need to complete evidence of insurability and return it to Reliance, and she wouldn't be charged until that was approved for coverage. However, Ms. Skelton's employer had also sent benefit verification documents to Reliance and thus began charging her premiums for supplemental insurance coverage. But it came out in the case that there was no evidence that Ms. Skelton had actually submitted the requisite evidence of insurability to Reliance. And so the employer sent those premiums for its employees in a one check and a worksheet, which listed the total number of employees. It's a very common practice known as bulk billing. And Reliance system didn't have the information that would allow it to determine or discern that it was receiving premiums from someone like Ms. Skelton, who had not or should not yet have been enrolled. And so the court relied largely on the policy, which makes Reliance a fiduciary for Ms. Skelton's eligibility and enrollment, because it had expressly delegated Reliance to be a claims review fiduciary, and found that it had exclusive discretion to determine eligibility for supplemental life insurance. So plan language, when analyzing or comparing your policies, it might be key to look at language and what exactly the express language is in the policy regarding enrollment and the insurer. But basically, Reliance's ability to decide Ms. Skelton's eligibility made Reliance the fiduciary for the application process as well. And so the court explained that there was, just because it received a bulk billing payment, that wasn't what made it a fiduciary there, but the fact that the policy was written as it was, and Reliance's practice with this employer made it a relevant fiduciary for this claim. And basically, Reliance had breached its fiduciary duties of both prudence and loyalty by not maintaining an effective enrollment system. So this is, a negative case for insurers, because it really requires a review of safeguards for systems that verify enrollment and collection of premiums. And the practicality is this practice is very common among the relationships between plan and sponsored employers and their insurers. And so a takeaway would be that life plans using bulk billing should consider conducting eligibility audits with their carriers or legal counsel. And now we are going to get into pending arbitration cases and decisions with Ian.
Yes. So arbitration continues to be a subject of a lot of litigation and court decisions. Kind of an oxymoron there, because arbitration is supposed to get you out of court into private proceedings, but these days it seems to generate as much court activity as anything else. The Supreme Court has continued to focus on arbitration in one way or another. It issued, I think, yesterday or the day before, it was yesterday, a decision finding exempt from the FAA certain transportation workers, and earlier in May it issued a decision dealing with the process for sort of challenging arbitrability. It continues to be a topic that's getting the High Court's attention, and I think many folks feel it's a topic in the ERISA space that will eventually land up at the Supreme Court because of the kind of confluence of the court's historical interest in ERISA cases and in arbitration. So with that, if we could go to the next slide and kind of recap where we have been. There have been a number of appellate decisions on arbitration in the ERISA context that have kind of gone in different ways. The Ninth Circuit in the Dorman case is probably the leading helpful case in dealing with arbitration. And there, the court essentially held that a plan could agree through its own plan document to arbitration. And one of the initial lines of defense asserted by the plaintiffs in these cases was to say, these are claims brought on behalf of the plan, and so if the plaintiff individual didn't have an arbitration agreement, that didn't, or had an arbitration agreement rather, that didn't matter because the claim belonged to the plan. And Dorman deals with that by saying, in that instance, the plan required arbitration, and many plans nowadays do. There was a way to get around that particular problem of who agreed to arbitration. The Cooper case, on the other hand, out of the Second Circuit, found that the particular employee's arbitration agreement didn't require arbitration of breach of fiduciary duty claims challenging investments in the 401k plan. It was a very precise reading there of what the arbitration agreement covered. And so, again, emphasizing that in order to make a plausible case to force a 401k related case into arbitration, you've got to make sure your agreement is in the right place with the right people. Smith gets to a third issue, which is, does the arbitration agreement take away substantive rights? So one of the things that the FAA, or Federal Arbitration Act jurisprudence, held is that you can't use arbitration to remove substantive legal rights. And in the Smith case, the Supreme Court said, even though it was applying the Schwab analysis, the case was not subject to arbitration because the arbitration agreement and its application in this case purported to take away the ability to get plan-wide relief. And in that case, the specific plan-wide relief was the relief of removal of the fiduciary, which was inherently going to affect multiple people in a plan. And so the court said, if you are going to preclude that by your arbitration provision, you're taking away substantive rights and violating the FAA, essentially, so that we're not going to enforce your agreement. And then the Hawkins case is another affirmance of a denial of a motion to compel arbitration. We can go to the next slide. There are a number of pending appeals in this space that are of interest. The Cedeno case is another ESOP case in which workers are essentially complaining about ESOP-related transactions. And the plan is trying to force the case into arbitration. The chamber has, as I mentioned earlier, has intervened in that case to file an amicus brief. The 10th Circuit's looking at the Harrison case as well in an ESOP case. And then an interesting case that's been argued in front of the Supreme Court, so we should get a decision any day, is the Viking River Cruises case. And the reason we put that on here is because there's sort of a parallel between the California PAGA claims or potentially a parallel between those and ERISA's kind of derivative suit on behalf of the plan type of claims. And the issue there is whether enforcement of a bilateral arbitration agreement precludes somebody from raising kind of one of these PAGA claims on behalf of others. So if the Supreme Court says that those claims are barred by the arbitration agreement, that might signal how it can come down on the ERISA issue, and obviously the decision the other way might hint at a different direction. So we should see yet another decision from the Supreme Court on arbitration very, very soon. So if we can go to the next slide, the takeaways here are, I think, everyone views it as quite likely that eventually we get up to the Supreme Court on the issue of arbitration. The court has had this historical interest in it, and if there is a ruling by the court that you can force plaintiffs in ERISA plan cases into arbitration, that may have a number of benefits. That said, there are some challenges that really need to be factored in the ERISA space, and we've done whole presentations on the issue of arbitration in the ERISA world alone, just that issue, because there's a number of considerations you really have to think through in terms of whether you want to have an arbitration provision and what does it really get you. I've talked about the fact that in an ERISA case, often the plaintiff will bring suit under 502A2 of ERISA, which allows a claim on behalf of the plan. And if they bring that claim and are able to bring it in the arbitration, a ruling by an arbitrator that's affirmed then by a court could effectively operate as plan-wide relief, and that's certainly what the Smith case out of the Seventh Circuit suggests. So, I think there's a significant consideration there. Even a one-off, single plaintiff claim of the right type could have potential plan-wide repercussions. So, if you take a 401k fee case, for example, and if you just had a plaintiff who was willing to sue over their own loss in the plan, if they end up in arbitration and the arbitrator rules that that particular plaintiff's loss was the result of a breach of fiduciary duty because the plan, maybe the investment option was imprudent or the fees were too high, then that may have a trickle effect down to other investment options in the plan or more broadly across the plan than just that particular plaintiff's account. And so you'd have to think about, if you're the plan fiduciary, well, what do I do now that I've got an arbitrator who said there was a breach with respect to participant X? What do I do about the other 35,000 participants in the plan? So it's quite an interesting set of things to sort of work through and process in terms of whether you want to try and put arbitration provisions into your plan. And then we obviously have, given the number of appellate court decisions we've covered, the significant issues about whether those provisions would be enforceable in the end. The other thing that is happening kind of in this mix is legislation, and I think everyone is aware, of congressional efforts to enaction to limit arbitration in certain instances like sexual harassment cases, and so there, the notion that arbitration is somehow a negative, a secret process for corporate America to avoid scrutiny, I think has had some traction in Congress, and there is certainly a risk that they decide to go after this issue. And with that, I would ask, I think we have a CLE code, and Kate, if you could read that out.
The CLE code for this webinar is S as in Sam, S as in Sam, 3201. That's S as in Sam, S as in Sam, 3201.
And I want to hand it back over to Rebecca at this point to talk about, so I just mentioned legislative action, and I was sort of planting the seed because, in fact, there is some. So, Rebecca, take it away.
Thanks, Ian. So on the next slide, one more, we are going to talk about the current bill titled the Employee and Retiree Access to Justice Act of 2022. So here's the direct text from the bill, which arrived last month. Basically, this pending legislation, if it goes, would effectively prohibit arbitration clauses in ERISA claims and prohibit discretionary clauses. And both of these, as you've just heard regarding arbitration, are huge issues. We've talked about SCOTUS potentially taking up the issue, but this is another avenue that we want to keep an eye on. The bill right now is under consideration, and so far it has only been sponsored by Rep. Mark DeSalner from California. And in response to it so far, we've seen a strongly worded published letter from the U.S. Chamber of Commerce as well, addressing both discretionary clause importance and arbitration clause importance as well. It basically makes the argument that, contrary to its name, these prohibitions would limit recovery amounts, increase costs of claims for benefits, and increase the time for courts to resolve claims for benefits, including time-sensitive claims such as sometimes disability claims and also sometimes severance claims. And so, the Chamber has taken a position in opposition to this bill. And interestingly, as Ian just mentioned, with the theories behind arbitrations and what they really do, in the letter, the Chamber included that, cited to this recent study, basically saying that limiting cases, including arbitration clauses and limiting class representation is not an attempt to abrogate individual participant ERISA rights. Rather, it's a reaction to plaintiffs' bar suits over COBRA notice violations and excessive fee and investment option cases, which, as we've heard today, have taken on quite or picked up rapidly. And so this study, or several studies that have come out in the past about 8 years, have found that arbitration is often cheaper and more favorable for employees. Employees were likely to win in arbitration at a rate of around 38%, and employees were tracking, or at least arbitrations that were tracked were winning slightly more money than they were in court, and arbitrations were resolved on an average faster than in litigation. And so, citing to these data points, the Chamber has set forth at least a path of resistance for this legislation. But both of these issues are huge, and so we will be keeping an eye on how this legislation develops. I think I went through the next slide. Or next few slides. That about wraps up my legislative updates, Ian, and that is all I have. And so thank you so much for attending this webinar today. And Ian, anything further from you?
Rebecca, I did see we had a couple of questions in the chat box. And just wanted to briefly try and address those, and obviously feel free to send any more. You know, we're trying to be respectful of folks' time, which is precious. But one was about essentially proprietary fund challenges in 401k litigation, and that does continue to be an issue. I think that you know, there was a round of litigation earlier on, you know, dealing with a number of the large financial institutions that offered their own products and plans, and I think mostly those cases have resolved. The plaintiff's bar has now taken to challenging, you know, what they sort of lump in the same category as proprietary investments, and they're investments really offered by a service provider to the plan. So, you know, if you have an investment advisor of the plan who also happens to offer, you know, investment options, and those investment options end up in the plan that's being advised by the advisor or the affiliate of the advisor, you know, that has prompted several lawsuits challenging them. There was a decision, I believe it was middle of last year, in the Lowe's case. I think of it as Aon, because Lowe's resolved the claims against it, and the case that went to trial was against Aon over use of proprietary investments, and kind of echoing or demonstrating, I guess, the point I made earlier about the proof. The case went to trial, a bench trial, and the judge ruled for the defendants in the case, ultimately finding that, you know, there was no substance to the claims, that these were imprudent, excessively expensive investment options that had just been put in the plan to kind of line the pockets of the provider. So, you know, there continues to be some litigation about that. There's a number of newer cases that have been filed kind of along the same lines, and I think, you know, certain of the plaintiff's lawyers are kind of branching out in that area. You know, we'll continue to chip away at these cases, but they ultimately all boil down to the same thing. You know, is the investment option prudent? Is the you know, is the process good? Was the fiduciary, you know, loyal? Did they consider the best interests of the plan participants and beneficiaries? And so, you know, those kind of central points continue to be the key things that you need to focus on in these cases. One other question that came in was about, you know, there was a spate of litigation about target date funds, you know, and that's continued to be a claim that's raised in a number of cases. I would say it's had mixed success with the, you know, on the part of the plaintiff's bar, rather. You know, some of those cases have been resolved, but they're particularly challenging cases for, I think, a plaintiff to ultimately win, because the difference in performance in target date fund suites, it's really a function of kind of the glide path and what the funds are invested in. And, what will happen is the plaintiff will often file a complaint saying, well, they had better luck articulating it, through the middle of last year, but basically saying, this target date delivered X performance, and if you look at, some other fund, it was much better. Well, often the reason it was much better was it was full of a lot of additional equity investment exposure, and so in a hot equity market did better. That's not the market we have right now, and so funds that have been more conservatively invested or have inflation protection in them tend to be doing better. So, again, it's a kind of evidence of the fact that proof is important in these cases, and getting the facts out in front of the judge can be quite persuasive. So, and if there are any questions that we didn't miss or didn't get to answering, we'll obviously try and follow up with you after the webinar.
All right. Thank you to our presenters. This concludes today's webinar. Thank you all for attending.